So what do you do if you're in Texas as opposed to Florida and you are facing debt collection? You've been getting letters, you've been sued, you've got stuff in your credit report. Well, today I'm talking to Bill Clanton, who is a Texas debt collection lawyer. He helps specialize in debt defense for people who are facing junk debt buyers, debt collectors, and other types of unscrupulous characters. And we're going to be talking about everything that he's seeing in Texas, comparing it to what's going on in Florida. My name is Michael Wasylik. I'm with Ricardo and Wasylik here in Florida. And together with my partner, Jason Ricardo, I help people just like you overcome foreclosure and debt collection. And today we're going to tell you about the differences between Florida and Texas in terms of debt collection, court action, communications, and credit reporting. Bill Clanton, welcome to the video. Thank you for showing up. How are you doing today?
I'm doing great, Mike. Thank you for having me on. I appreciate the chance to talk state differences with you.
Well, super. I'm looking forward to this as well. Those of you who've been following our channel for a while know that whenever somebody says, hey, I'm in Texas, can you help me? I almost always say Bill Clanton in San Antonio. He's the guy you need to call. He can handle everything across the state of Texas. And I've had some feedback saying that people who've called Bill have been very, very happy that we were able to hook everybody up because Bill can help them. So Bill, why don't you tell us a little bit about your background, your history, how you got into debt collection, anything else you think is important for us to put in context of what's going on with you and your practice?
Well, I never planned on becoming a lawyer. And when I first started, I did criminal defense work, so I wanted to help people out. I kind of got burned out on that. And this was around 2008, 2009, when the economy was burning out as well. And I started seeing people getting sued on debt. There was so much bad debt and so many lawsuits. I started defending those cases, then started seeing violations of the Fair Debt Collection Practices Act and the Credit Reporting Acts and state laws. And so I started suing debt collectors and credit reporting agencies on behalf of consumers. And now I defend consumers in state court and sue debt collectors and just try to help people out.
Now, as I understand it, that's almost entirely what your practice is now, like almost completely devoted to protecting people from debt collection and unscrupulous debt collection efforts.
That's right. Yeah, that's what we do here.
Great. It sounds like a lot of what kind of brought you to where you are now is similar to kind of our approach. Like we have this whole David versus Goliath mentality where we have these, we have people who are faced with these debts they got kind of sucked into by these large lenders, these credit card companies, these banks. We do a lot of foreclosure work as well. And we see people who sign things they may not even really understand. And suddenly at the end of the day, or after something like a pandemic, they find themselves kind of trapped in this situation where they don't know their way out. And it sounds like you're in the same kind of David versus Goliath mode. Is that fair?
Absolutely. Yeah. I think of myself as the David against the Goliath of these huge organizations. One of the big players out there in the debt collection industry is Midland. They had over $1 billion in revenue last year. It's insane the amount of money and how big these Goliaths are. And so being a David is certainly how I consider myself and the role I enjoy playing.
Well, I tell you, it's always fun for me when I hear somebody come to me and say, well, we didn't think that we were going to be able to overcome this, but because of the things that you helped me with, that we were able to get something taken care of, get rid of that lawsuit, get rid of that debt collection effort, and get rid of negative items on the credit report. So I know that using that kind of slingshot that like David did against these big players is always very rewarding. So
it is.
I'm glad that you were able to come to this. So one of the things that I see, Bill, and I think that, based on, you and I have known each other for a while now.
Yeah.
And so you see a lot of the same things as I see. There's kind of three big areas where people run into this debt collection Goliath. And it is, number one, they are getting sued in small claims court or even, a higher court for some amount of debt. Usually it's involving a credit card case. You mentioned Midland. We see others like Portfolio, Cash LLC, LVNV, Cavalry, other junk debt buyers like that. Sometimes you'll see MX and Discover and Cap One. And so you see those small claims court actions. Number two, we see people worried about communications, like they're getting letters or phone calls from debt collectors. I hear, for example, people who have complained about phone calls going to their mother-in-law about their own debts and things like that. So those communications are a problem. And then thirdly, credit reporting, which especially in the wake of COVID with the CARES Act, can be both a big problem, but also a big opportunity. And so, I want to kind of hit, if we can, like all three of those topics in sequence. But I know that there's a couple of things in Texas that are really interesting about how you handle the type of small claims court actions versus something I might see here in Florida. And before I even launch into this, there's a reason we're talking today about Texas versus Florida. And that is because Bill's licensed in Texas, I'm licensed in Florida, and we get a lot of calls or questions about, can I help somebody, I'm from X state, can I help you there? And the answer is almost never, we can almost never cross boundaries, right? Unless we're licensed where we go. And so whenever somebody says, I'm in Texas, I need help, that's when I say, well, call Bill.
Right. And I know there's a lot of folks on YouTube who found me through your videos. So I appreciate you bringing me onto your channel.
Absolutely.
And just like you, I'm only licensed in state court in Texas, and I can only handle state court actions in Texas. So whenever somebody from Florida calls me, I send them to you, or other states. So I send them out to folks that I know and trust in other states.
Yeah, and we're always looking for lawyers in other states that we know, like, and trust, so that we can make sure that when we send somebody to them, that they're well taken care of. And I'm just going to say, Bill is somebody that I highly recommend. Anybody in Texas, talk to Bill. But let's talk a little bit about like some of the things that you see in Texas regarding these, especially with these junk debt buyers in small claims court. What kind of things do you see? And then there's that one wrinkle we talked about earlier before the call started, that one wrinkle in Texas that I find really fascinating that doesn't seem to exist in Florida, but you may use to your advantage when you've got somebody in Texas.
Right. So debt collection cases in Texas have traditionally been filed in small claims court. Small claims is also known as precinct court or JP court, Justice of the Peace court. And every county is subdivided into smaller precincts. I'm
sorry, how big are the claims you'll see in that small claims or JP court?
That's a great question. So up till the end of last year, the statutory cap on those courts was $10,000. But I believe it was either September of last year or January 1 of this year that cap was doubled. So the claims up to $20,000 can now be brought in those small claims courts, which is huge because most of these debt collection cases are for $5,000 or $6,000 or $7,000. Some of them, some less, and occasionally more, but almost none of them are above $20,000. So all these cases are going to be filed pretty much 80, 90% maybe now are going to be filed in these small claims courts.
Right. So in Florida, we just bumped it from $5,000 to $8,000. And like you said, the typical small claims lawsuit we see that, and in fact, most of the lawsuits we see, they're around the $5,000 range or less. And so every once in a while, we'd see one for like $6,000 or whatever. Now, all of those are in small claims court, which here in Florida is a simplified system that's designed to be heard without lawyers most of the time. But still, if you don't have, but the Midland portfolio, all those guys, they always have lawyers. So they're always using those rules to their advantage against the borrowers in our case. I'm sure you've seen something similar.
Yeah, in small claims court, you can represent yourself. I mean, you can represent yourself in any court, but the small claims court are especially friendly to pro se people representing themselves. And of course, just like Florida, the Midlands, portfolio recoveries, Calvaries, LVNVs, they all have lawyers. They all have lawyers in offices in Houston and Dallas that are filing their pleadings, and they have lawyers on the ground here in San Antonio and every other city that are actually going to court for them.
Now, in Florida, we see Midland in particular, and I think to a limited extent, some of the other junk debt buyers, we see that they have a small cadre of lawyers in-house, but they also outsource some of their cases to other law firms around the state. Do you see that in Texas as well?
Yes, yeah. All the big debt buyers Midland will file some of its own cases, but they'll also send it out to other law firms to file and handle their cases. And like Portfolio, for instance, they have 3 or 4 different law firms that file their cases.
Yeah, we see that here as well. I think there's like 2 or 3 that we really see most often with Portfolio cases. You know, for the most part, you know, I'm sure that you've found the same thing. Like once you kind of know who the players are, like once you see these cases again and again and again, and you know who to talk to, it makes things a little bit easier to resolve without, you know, going, you know, resolve, frankly, you know, what we find is it's fast, you know, cheap and easy to resolve once you know who you're talking to.
Right. Yeah. Establishing contacts at the debt collectors and the law firms has been a big help in getting these cases resolved.
Would you say that you've been able to establish relationships with those people, the most common filers?
Yes. Yeah. I've got contacts at sometimes with the actual entities themselves and others with the law firms. But yeah, the big filers, we talk. Yeah.
One of the things I found is that once they know who we are, you know, and now it's a question, once we, you know, as soon as we file our court papers, they're reaching out to us instead of vice versa. And they're saying, hey, what do you guys want to do? You know, and I can't obviously talk about details of specific settlements, but, you know, once they know we're involved, they know that we have a particular way of resolving things that usually gets those cases taken care of to our client satisfaction. I'm sure you've seen the same thing.
Yeah, it changes the way they work the case, for sure.
Oh, sure it does. Yeah. So you were talking about the precinct system in Texas and the kind of the special Texas lever that you've got when junk debt buyers and other debt collectors file lawsuits in Texas.
Right. Yeah. So the Fair Debt Collection Practices Act says that a lawsuit has to be filed in the correct geographic location. And courts have decided that that means the smallest geographical location that's a part of the system in which the case is filed. And so the small claims court system in Texas has these precincts, which are subdivisions of counties. And so if a case is filed in the wrong precinct, then that's a violation of the Fair Debt Collection Practices Act, the Texas Debt Collection Act, and can give rise to either an independent lawsuit against the debt collector or a counterclaim within the lawsuit, which can lead to a great deal of leverage in negotiating those debts and can actually put some money in the pockets of consumers. So
by comparison, here in Florida, we have a county court system, which is the smallest court unit. So if a debt collector is suing somebody here in Florida, they'd pick the county where the person lives and they'd sue in that county. But in Texas, they not only have to sue in the right county, and you're in Bexar County, is that right?
Right, that's right. Okay.
So you're in Bexar County, but you handle all over the state. But Absolutely. In Bexar County, there are, I think you said there were 4 or 5 district or precincts. They have to not only pick the right county, they have to pick the right precinct. And if they're in the wrong precinct, they've broken the law.
Correct. Yep. That's absolutely right.
Yeah. So that's something that I think is pretty distinct to Texas, certainly something that we don't have here in Florida, because the county is almost always they almost always sue in the right county. But in your case, if they don't have the right precinct within that county, that's when the violation crops up.
Yes.
How often does that happen?
You know, it used to happen, be fairly common. It's less common now, but it's certainly the first thing I check out. When somebody calls me, I get their address and check it against where it was filed to look for these venue violations. So it still happens, maybe 1 out of 10 now instead of 1 out of 5 like it used to be.
Okay, so it's still pretty good odds that at least 10% of the cases you see are involving some kind of geographic area violation. Then.
Yes, yeah, at least 1 in 10 have got some kind of violation like that.
Now, without disclosing settlement details or anything like that, how valuable is it when you find that type of violation? Like, how much can you offset of a debt?
Well, typically these debt buyers, they buy, millions of dollars of debt at a time. And so somebody's $5,000 debt is not much to them. And it's not much for them to give up, because for a $5,000 debt, they may have paid, maybe they paid $500, maybe $250 really, or maybe even less. And so frequently I've been able to negotiate the elimination or the extinguishing of those debts in settlement of those claims.
Got it. So, I mean, I like to say that they're paying pennies on the dollar and they're trying to squeeze nickels, dimes, and even quarters out of the people that they're suing. And
Absolutely.
It sounds like your experience has been the same. Because a violation of debt collection law, and I'm going to circle back around to something you said earlier, which is that it violates not only federal law, but also potentially Texas law, right?
Yes.
And so one fun thing we like to do is whenever a debt collector is coming into Florida court, we like to look where they're coming from, right? Because Florida has a debt collection statute as well. So we have the federal, we have the state, but we also look to the state where they come from. So for example, I want to say, well, I know Midland is in California. California has a debt collection statute that is also very strict, right? So if Midland violates a debt collection practice, oftentimes we can stack 3 different laws up because they violated the federal law, they violated the state law in Florida, they violated the state law in California. And then instead of saying, well, you owe $1,000, we can say, well, you owe $1,000 here and $1,000 here and $1,000 here. So it's a $3,000 violation for them.
Nice.
And I'm trying to remember, there's at least one major debt collector from Texas. And it's not Portfolio though. Which do you know?
Portfolio's from Virginia.
Yeah, Portfolio. Virginia.
There's, of course, you try to think of it and its name escapes you.
Yeah, it's like the moment we ask the question, it vanishes. But you know what? I'm probably thinking actually of a mortgage servicer. There's a couple that are based out of Texas, so I'm probably thinking of that. But definitely speaking, if you're in Texas and you have a state statute on top of the federal, and you're dealing with somebody from, for example, California, or even another state that has a robust debt collection statute, you can certainly stack those things up and make the dollar value. Like, you could put money in somebody's pocket potentially if you've got a large enough violation and a small enough debt, right?
Absolutely, yes.
Okay.
I don't ever see, so, the FDCPA says there's a $1,000 penalty. The state statute in Texas does not have a statutory penalty.
Okay.
It covers actual damages, but it does give injunctive relief. So,
oh, nice.
While the federal law doesn't give injunctive relief, the state law does. But then the state law doesn't give actual statutory damages, and the federal law does. So
less money, but more kind of mandatory relief where they have to obey the law. Right. And of course, all of these come with attorney's fees, which means that if there's a violation, certainly we're usually able to say if there's a violation there, then we can work for free to the consumer because we're getting our fees out of the other side if we settle in most cases. And when you're able to stack those statutes, I mean, you don't get more than one set of attorney's fees, but it's always, there's more than one way to get those. So it's usually, in my experience, and probably yours as well, if there's a violation there, that means somebody can come to you and it's free or at least very cheap, right? I don't know how you work. So
yeah, absolutely. So for debt defense, I do charge a fee, but for just suing a debt collector, I don't charge any fees because I get paid by the debt collector at the end of the case.
Right. And that's the same way, we have this, we have this one weird set of circumstances where if somebody's being sued, we do have a fee, but if there's a violation, then we can waive the fee. And so it's a question of, can we offset the two against each other? And almost always we can, especially if we can stack things. So
yes.
So if there's a violation, we're usually able to come in for free. And so, and what you're saying is, so can you. Because one of the questions I get a lot is, doesn't it cost more money to hire a lawyer to fight these things off? And I mean, in my experience, the answer is actually it's usually cheaper.
That's the thing that doesn't make sense to folks, in my experience, and yours is probably the same. The discount that I'm usually able to negotiate on a debt is much greater than what somebody would pay me.
Right. So if somebody comes to you for a $5,000 debt and pays you whatever your normal fee is, they're still saving money after you're done if they just try to do it themselves.
Absolutely.
Yeah,
it's been my experience. Yes.
Yeah, I mean, that's almost always the case for us as well. And then if there's a violation buried in there somewhere that we can uncover, it's not just free; it's actually money back to the client.
Yeah, absolutely. I make the argument that they've incurred attorney's fees because of the violation, that they're entitled to actual damages, statutory damages, and then my attorney's fees and costs.
Okay. So, I mean, really, anybody in Texas who's been sued for a debt collection violation, I don't want to call people names, but boy, it'd be really foolish for them not to talk to you, right?
Absolutely, yes. Yeah, they should first check to make sure that their case is filed in the right place, make sure the amount in the lawsuit is correct compared to collection letters and credit reporting, and then give us a call.
Well, and that's a great, I'm glad you mentioned that, because that's something that is really important, is that you have this process for uncovering these violations. And one of them is, it sounds like, again, similar to ours, which is, is the number right? And one of the things that all lawyers learn early on is, where else has the other side made statements about certain facts? And let's compare those statements over time and see if they all line up. So if someone says on the credit report, the number is $2,000, but in the lawsuit, they say it's $3,000, that's something that we can use to say, well, one of these statements is false. And so you're lying to somebody. And in the case of debt collection, lying about either one of them can potentially be a violation that puts money in your pocket, or more importantly, is leverage to get rid of the thing entirely.
Yeah, absolutely. Absolutely. We see the same thing. If somebody's got one amount in a collection letter, a different amount in a credit report or a lawsuit, then they can't all be true.
Right.
Right. And so there's a misrepresentation somewhere. It doesn't matter where a debt collector lies. Anytime a debt collector makes a misrepresentation, it's a violation of the law. Anytime
a debt collector lies, they're breaking the law, and you can recover for that, and you can take care of the debt pretty much.
Absolutely.
We'll talk about that a little bit more because I want to get to credit reporting before we finish today. But that is definitely something that, that's a trick we like to use in credit reporting. Is you've got 3 credit reports, and if the numbers aren't the same across all 3 reports, somebody's wrong. So
yes,
we'll come back to that in a minute. So with the court action stuff, I mean, small claims in Florida is, right now, because of the pandemic, everything's by Zoom. But even so, the way small claims works in Florida, like there's an initial court date that you have to show up for unless you've hired a lawyer, and the lawyer can handle it for you. But otherwise, you have to show up in person. You have to, make certain representations to the judge about whether it's your debt or not. And, you have to do all these things and go through mediation. And then if if it doesn't resolve that way, then you have to go to trial. And, again, you can represent yourself, but most people don't know how to do that because they've never been in court before. Is the Texas small claims process similar to that?
It's different, and I think there's some confusion amongst Texas consumers about that. A lot of folks feel like they have to show up in court. Once you're served in small claims court, you have 14 days to answer. So 2 weeks. Mm-hmm. And you don't answer by showing up in court. You answer by filing an answer in the court. Okay. And so a lot of folks worry about when they need to show up, or if they need to show up, or that they have to show up. And they don't. They need to get a document on file. And so, so there's some confusion about that.
Well, it's funny because I know that in Florida, a lot of people worry about having to take time off of work and go spend the morning or whatever in court. And so the physical appearance in court stresses them out. But the actual writing of a document, in my experience, that's something they should be more stressed out about rather than less, because the requirements of the document are stricter and tougher on people who are, especially non-lawyers, because you don't really know what to say. Is that true of what you see in Texas?
Less so in Texas. And I'm curious to see what it's like in Florida. But in Texas, you just have to do a general denial. And there's been cases that say that if you write your name and contact information on the paper and the case number, then that's enough. You just have to have something on file with the court so that they could identify you, who you are, or that you've actually answered. But in Texas, you can do a general denial. It's not like federal court where you have to do a specific denials of each allegation. Is it that way in Florida, or is it a specific or a general denial there?
So with small claims court, you don't file a written answer. You go to court and the judge says, do you admit or deny the accusations? And you can do a general denial, but you do it verbally. Now, again, right now, everything's by Zoom or by video conference. So you can do it that way. But the procedure during normal times is you have to physically go to court and tell the judge, yes, I admit it. No, I deny it. And you can deny it for any reason. I don't recognize, I don't know who Midland is, or I don't know who Portfolio is, or I think the number's wrong. And you don't have to you don't have to say that. You just say, Judge, I dispute it. And that's enough for them not, because if you say, yeah, I admit it, it's my debt and the amount's right and all that, I admit it, then a judgment's entered against you and the judge sends you out of the room to negotiate on what your payment plan is going to be.
Right.
And, that drives me crazy. But the written answer requirement is only if it's over the small claims limit, which again, in Florida, $8,000. If it's like a $10,000 lawsuit, then you have to file the written answer, which, in theory, you could file what's called a general denial, which just says, I deny the whole thing, but you really, and judges won't really blink an eye at a pro se defendant who does that. But the problem is you do have an obligation to write out what are called the affirmative defenses, what I call the yes, but defenses. Yes, it's my debt, but they wrote it off. Yes, it's my debt, but there's a statute of limitations argument. For example, statute of limitations is an affirmative defense in Florida. And if you don't actually list that in your answer, it's waived, it's gone, bye-bye. And
Right.
so if you have a debt over $8,000 in Florida, you have a written requirement. You have a requirement to file a written answer. And if you don't do that properly, you can lose defenses because you didn't know how to respond to it. But in small claims court, it's just admit or deny, and you can on that first date. And then if it doesn't resolve on that first date, then it gets set for trial sometime down the road.
Now, it sounds like you may experience one of the things that I experience is that folks are unsure about denying the allegations. I owe the debt. Well, and deny doesn't mean that you're saying you don't owe it. It means that you're saying that you want them to prove that you owe it. And if they can't prove it, then even if you may owe the debt, then they can't collect it from you.
Well, and I like to use the word dispute instead of deny for that reason, because I think that most people are honest. Most people want to resolve these things, and most people want to take care of their obligations. And so the idea of deny it doesn't feel right to people. And so I like to say, if you dispute it, all you're doing is you're not rolling over, and you're giving yourself a chance to resolve it in some other way. Because if you admit it, there's a judgment and you're done. Then it's wage garnishment, which I know is different in Texas. All kinds of things, once a judgment's entered against you in Florida, there are consequences that can flow from that. And so I always tell people that disputing it, that doesn't, If it's really your debt and the amount is correct and everything else is justified and you have no defenses, you can always come back later and say, here's a check for the amount. But if you admit it from the get-go, you lose all of your legal rights. And if you say, Judge, I dispute this, all you're saying is, I may have legal defenses and I may want to raise those defenses, because you can always come back and say, you know what, it's fine, I'll pay it, right? If it's really your debt, if it's really the right amount, if you really, if it's not beyond the statute of limitations, if there's no other legal reason that you don't have to pay, you can always come back and stroke a check. But if you come in right away and say, I admit, it's game over, and you've waived everything that you might have, all your legal rights are just flushed down the toilet.
Right.
So
one thing you mentioned, what kind of post-judgment remedies do creditors, judgment creditors have in Florida?
So that's a great question. I get that a lot. And so post-judgment remedies are oftentimes what trigger people to come to me. So if you are working in Florida, you can have your wages garnished, which means that a creditor who has a judgment can take up to 25% of your paycheck. Now, there are protections, there are exemptions. And if you are supporting, for example, a spouse or kids or whatever, there are protections that you can invoke. But if you are a single person, or you are let's say your spouse is the breadwinner and you get paid less than your spouse does, up to 25% of your wages can be removed from your paycheck without your permission, against your will. Same thing goes for bank accounts those wages go into. If you own vehicles, certain vehicles can be subject to garnishment. Now, Florida is famous for having a broad homestead protection, meaning your home cannot be the subject of that kind of lien or garnishment, although in other states they can be. That's why some very famous people built homes here, like O.J. Simpson built a home here when he was being sued by the Goldmans. The Enron folks built, they built homes here, which were second or third homes, but they moved into them, and they spent millions of dollars on these homes to protect their money, because you can't take someone's home in Florida unless it's for a mortgage or if someone does work on your home, generally speaking.
Right.
So, the post-judgment remedies primarily are going to be garnishment of either wages or of the bank accounts those wages go into, seizure of vehicles, seizure of non-homestead real estate. So if you own rental properties or anything like that, if you have stocks and bonds that are outside of a retirement account, that can be seized, things like that. So Florida does have a pretty broad post-judgment remedy. In other words, a creditor with a judgment can really take a lot of your stuff. So you want to avoid that judgment if at all possible. I understand Texas is a little bit less severe, but there still are consequences.
Well, yeah, it seems like it on the surface. So Texas has got broader exemptions. You get your house, and it's part of the Texas Constitution. It's one of the oldest statutes in Texas, one of the oldest rules in Texas. These broad exemptions: your house, a car for every licensed driver, contents of your house, two firearms. The statute lists a number of head of cattle and sheep and chickens, and it's like I said, it's old.
That's amazing.
I think Texas was established by people who are running from their debts. So
I don't know any other state that protects chickens.
Oh yeah, no, I forget the number, but it's in the statute. Yeah, and so. Texas does not allow wage garnishment either.
Right.
So this leads to something very interesting. They can garnish your bank account. So they can come and freeze your bank account and take the contents of your bank account, unless it's a Social Security or child support benefit or something like that. But what's come into vogue, the law changed in 2017 to allow receivers to be appointed. And so what these debt collectors will do is Midland or Portfolio will send out a set of discovery to people. And like 90% of cases are default judgments, meaning a no answer default judgment. The consumer did not answer the lawsuit. And so the debt collector got a judgment. I'm sure the numbers are similar in Florida.
Right. I mean, that means that somebody got a summons and just ignored it, didn't answer, didn't show up. Like in Florida, they show up for court. If they don't show up, they get a default judgment. In Texas, if they fail to file that written answer, that's a default judgment.
Yes.
Okay. So they ignored it and didn't handle it, buried their head in the sand instead of dealing with it.
Right. And so what that leads to in Texas is they'll get mail from Midland or Portfolio, which are discovery requests saying, admit that you have assets that are subject to receivership, or admit that we can take everything you own. And then they'll use those admissions to get a receiver appointed as evidence in a receivership hearing. And they'll get a receiver appointed who has incredibly broad powers. The receiver can pull your credit report, pull your bank statements, et cetera, et cetera. And so they'll get a receiver to pull your credit reports, find out where you bank, and seize your bank accounts. All you have to do is send the bank a letter and the receivership order, which is a lot cheaper and easier than a garnishment proceeding. So that's been in vogue lately, and it's debilitating to people when a receiver freezes their bank accounts. They no longer have their card, they're pumping gas and they can't pay the card. They go out to eat and then a receiver freezes their bank account and they can't pay for the meal. I've heard all kinds of stories like this. It's much worse. So I feel like having wage garnishment might be better for folks than having these receiverships.
So in Texas, you could literally be stranded by the side of the road with no gas. You could be stuck in a restaurant having to wash dishes because your credit card won't work.
Exactly.
Or you don't have any money to pay.
Right.
And the admissions part of it, you mentioned the mail, like a letter in the mail with a request for admissions. I mean, lawyers will immediately kind of get the hair on the back of our necks, to the extent we have any hair, standing up right now, because admissions are another one of those things that if you get something and ignore it, it has tremendous legal consequences.
Absolutely. Yeah.
Okay.
People don't know what they are. They ignore it. They think it's another collection thing. They throw it away, and then accounts are frozen. And
damn.
It's terrible.
Oh, so yeah. I mean, I would certainly, based on what you're talking about, I would certainly rather have wage garnishment, because there's absolutely protections against that here. Like when you can't have your wages garnished without getting notice and a right to go to a hearing in court. In Texas, it sounds like those admissions, like if you get that envelope, or even if you don't get it and they say you got it,
right,
and they go to the judge and the judge says, well, you proved you mailed it, so we're going to go ahead and proceed as if they had admitted all this stuff.
Yep.
Oh,
and they just sign off on these things all day long. And here's the even sneakier. I've seen some of these motions that are ex parte motions to appoint a receiver. They're saying they need to be ex parte so a consumer doesn't go and hide their assets from a debt collector. And most consumers don't have significant assets, enough to satisfy a judgment in a single swoop. So it's ridiculous.
So in other words, they're sending out these requests for admission. They're saying, admit this thing is true, and they really know it's not true.
Absolutely. Yeah.
And they're depending on people to ignore it, because people are either not understanding what it is, or they're afraid to respond, or whatever causes, or they just don't get the letter that day.
Right.
And so that's how Midland and Portfolio and those other junk debt buyers make their money, because somebody doesn't respond for whatever reason. Maybe there's a bad winter storm and the post office stops delivering mail or something.
Yeah, imagine that.
and just all of a sudden, maybe they have 1,000 judgments and they get 50 of them where these people have ignored their mail or didn't respond to their mail, and all of a sudden they've got 50 cases where they've got this extreme power to seize people's assets.
Yes. Oh, and I forgot, they can add a receivership fee, which is commonly 20 to 25% of the judgment. So it increases the judgment by 20 to 25%.
Wow. So that's like a double whammy. So one of the things we're seeing a lot lately is we talked about default judgments when somebody fails to respond to a court lawsuit. And one of the things we're seeing people complain about lately is, I didn't know about the case. They never got a service. They never got a summons. They never had a process server, knock on their door and say, here's a court case, you've been sued. And yet somehow the court is being told that has happened. Are you seeing that? And if so, can you kind of untangle that problem a little bit for people who might be experiencing that?
That happens sometimes. Yeah. There's what's referred to as sewer service. or you get an unscrupulous process server who throws summons into the trash saying you served them.
Or even an innocent mistake, right? Maybe they served the house next door and write down the wrong way, or.
Yeah, that happens. And then another thing that happens in Texas is substitute service. I'm sure you have something similar in Florida, but after a process server makes 3 to 5 attempts to serve somebody at a particular address, they can get an order from the court allowing them to leave it at the doorstep or tape it to the door or whatever. And so it's inherently flawed. It's not ideal. And so people will say, oh, I found a piece of a lawsuit on my doorstep, or people worse will not even see the lawsuit, or the kids will take it and throw it away, or it gets lost. It's unreliable
or something like that even. Yeah.
And then they get a judgment against them. They don't know. They legitimately never got it, even though the the process server can say that they served it. The folks never got it. And so those cases can be decent cases for a bill of review, which is a separate lawsuit to reopen an old case where service was improper.
So there is a remedy for that then. Like if somebody comes to you and says, hey, Bill, I didn't even know about this. There's a judgment and a garnishment, and suddenly I'm being attacked on all sides, and I never knew about this case and you look at it and said, oh, well, here's this substitute service where they taped it to your door. Is that something that judges are reasonably open-minded about in your experience?
It varies from court to court and judge to judge, but yeah, that can be the basis for what they call a bill of review, which was a separate lawsuit to reopen the original lawsuit. But oftentimes it's more to the consumer's advantage to try to negotiate the debt with the threat of to the debt collector with the threat of a bill of review. Right. You know, it can be more cost effective for that, because a bill of review it's not a simple lawsuit.
We have something similar in Florida where it would be a motion to vacate. It's a motion in the same court case, and we would say, all right, well, so for example, here in Florida, our version of substitute service is any person living in the property, right? Anyone over the age of 15. So if my 16-year-old son gets a copy of a lawsuit from me and is angry because he just got grounded and decides not to show me the papers, and I could come in, I mean, a year later, 2 years later, 3 years later, say, I never got it. And if the judge agrees that I never got it, then they could reopen the case. But definitely, you know, for cases in small claims court, it can be a lot more cost effective just to negotiate a, you know, let's write a check for a smaller amount, clean up the case. And in some creditors are willing to, for example, delete the trade line from the credit report, meaning take the negatives off, right? And so depending on who you're dealing with, that might be an option as well. So right.
Yeah. How long can you file a motion to vacate in Florida?
So if it's a service of process issue, it's I'm going to delve into some lawyer speak here. It's a jurisdictional issue, and therefore the judgment is void. And so what that means for the non-lawyers who are watching this and scratching their heads, if you've never been validly served, then the court doesn't have the power to rule against you, and therefore any attack on that improper ruling can be made at any time. So Florida's Rule 1.540 in Florida, which is a motion to vacate, is if it's a service of process issue, it's at a quote reasonable time, but there's effectively no time limit if it's actually void, which means you weren't properly served. So it's very, very broad. As a practical matter, the longer it's been, the less sympathetic a judge is going to be, and the less likely they are to believe you didn't know about the lawsuit.
Right.
And if there's any kind of, if there's any activity in the court case that suggests you did know about it, you're going to lose, right? So if there's a bankruptcy, or if there's a, any kind of response by you at all, and then you come back years later and say, I didn't know about the lawsuit. Well, the judge is not going to believe that, because, well, you filed bankruptcy here and you mentioned this judgment, so I know you knew about it. So legally, there's no time limit. Effectively, the sooner the better.
Yeah. It's the same for service in Texas. Generally, there's 4 years for a bill review, but if there's no service, it can go on indefinitely. But
Okay.
just like in Florida, the further out you are from the judgment, and if there's any indication you knew about it and didn't take action, then that can be a real hindrance.
So the takeaway from this part of the discussion is, if there's any hint that you've been sued, if there's any hint that maybe somebody has come after you in court, you need to take care of it right away. You need to find out what's going on. You need to talk to a lawyer soon so that you can, if you need to, you can act quickly to resolve the issue.
Absolutely. And even if your case has gone to a default judgment, it's not over.
Right.
There's always resolutions on judgments and or case reopenings or negotiations that can take place after that.
So I know that we've had cases where somebody come to us when they had their wages garnished, so I've had people say, oh, well, they served my mother-in-law who lived in a different house, and I wasn't there and I never knew about it, and she didn't speak English. And so I didn't know the case was going on. And we were able to negotiate with the judgment creditor who owned the judgment. Hey, listen, here's not all of it, but here's some of it. Will you go away? And that is often a successful solution to the problem. And like you said earlier, it can be cheaper than attacking the improper service.
Right.
Now, do you find that in cases like that they are, because a judgment on your record the public record issue can sometimes be a problem for people. If you've got a security clearance, if you've got, a sensitive job, if you've got, there's the number of reasons why people might not want a judgment against them. If your clients are willing to cough up a little bit of cash, do you find that some creditors are willing to vacate judgments, or is that something that's pretty rarely done?
No, absolutely. When a judgment's paid off or negotiated, I always negotiate the release of the judgment and release of any publicly filed, what they call an abstract judgment in Texas.
Okay. Well, I don't know what that term means. We don't use that.
So you can't have a lien on your home in Texas because it's exempt, right? You can't have a lien on your homestead property in Texas. It's exempt. So they can't go and file a lien on your home. But what they'll file is an abstract of judgment, which is a document that is filed in the official public records of the county rather than a court system that recognizes the judgment.
Mm-hmm. Okay.
And so part of the settlement of cases where there is a judgment and an abstract of judgment, you get the abstract released and the judgment released. Okay.
So that's an acknowledgement that the judgment has been satisfied, or does it wipe out the judgment entirely?
The release is an acknowledgement that it's satisfied. Yes, okay. Satisfaction of judgment and release of judgment is filed with the official public records.
Yeah, we have something similar in Florida. It's a document called a satisfaction of judgment that gets recorded once the judgment is paid off or settled. And so sometimes, depending on if you've got somebody who is in a sensitive job or has a security clearance, it may be, sometimes we'll want to negotiate. We'll pay you, X amount of money, and you agree to vacate the judgment, meaning wipe it out entirely as if it never existed. Now, usually that's going to cost more money because it's a bigger deal. It takes more time and effort. Is that something that you see at all, or is that may not even be a thing in Texas?
I've never negotiated separately for a lease or satisfaction of judgment. That's always part of the terms of the settlement of the judgment.
Got it. Okay.
Once it's paid off, Midland and Portfolio Recovery and all these other debt collectors, they want to make money, and so they'll generally take payments. So once these judgments are paid off, they will send in a release or satisfaction of judgment.
Right. Yeah. No. Yeah. Money is usually the ultimate tool to get them to do what you want, is what I found. Or, depending on the case, there's other tools you can use, but, let's do this. I think we've covered the range with the court action stuff, which I think is probably the most important, most dangerous to most people. It's where most people, I think, make the biggest mistakes. Right.
Right.
but there's a couple other areas. We were talking a little bit about communications, debt collection, letters and phone calls. And there was one letter in particular that you were talking about that's being sent to people in Texas. We have a couple of videos about specific letters, and I think you probably have seen those, where we talk about, well, the letters they're sending you that are demanding payment, we believe they may violate the law. And you found one that you have seen in Texas that is particular, and you actually have a copy of that letter with you now, don't you?
Yeah, I sure do. It's a
show us
Midland
that
letter.
and tell us about that.
And it ties into what we're talking about with liens in homestead exemptions and things like that a moment ago. So Midland's been sending out this letter I'll hold it up here for the camera.
Okay.
Can you see that?
So
they've been sending out this letter that says attorney review planned, final notice. Mm-hmm. And this is a scanned printout of this letter.
Okay.
And so this gray area is yellowed to make it look like an old piece of paper, right?
Right.
This final notice is like a red stamp on there.
Okay.
The attorney review plan is black with white print on it. And it says here that they are going to turn it over to an attorney to sue. What will an attorney do? They will seek to obtain a judgment. How could a judgment affect me? They obtain a lien against your property.
Wow.
As we just discussed, they can't obtain a lien against your property. They can obtain a lien against your non-exempt property, but that's such a small subcategory of most people's property that saying that they can put a lien on your property is a threat, a false threat. It's a lie by a debt collector to intimidate you into paying them. And so Midland's been sending this out to nearly everybody that they have sued the last few years. I ran across this letter last year, and I think anybody who's received that letter has got a case against Midland for these threats, these overbroad threats that they'll take your property.
So because Texas protects your home, your cattle, and your chickens, that letter is actually a lie, because it doesn't really, it leads people to the false belief that Midland could take your home, your cattle, or your chickens, even though the law expressly denies them that right.
Right. Yeah. Your home, the contents of your home, a vehicle for every licensed driver, they're all protected by Texas law. Now, unless you have a second home, or you have a bunch of cars, or you have too many cattle or chickens or too many firearms, then, they could take that property. But again,
no more, right?
Most people who are being sued on these types of debts don't have assets that are non-exempt. They're what they call judgment proof.
Okay.
Occasionally somebody will have a second home, but not often. And so most people are exempt from have a significant amount of exempt property in Texas. And so this threat that they'll put a lien on your property is false.
And so that would violate the federal statute, number one.
Yes.
Based on and I'm not a California lawyer, but I've filed lawsuits in Florida against California debt collectors. And so I know the California law also that letter would also violate the California law. So
yes.
So then you've got $1,000 in statutory damages from the federal law, another $1,000 in the California statute. I believe the California statute has statutory damages as well. So you're stacking damages there, meaning that the one violation could, ring multiple bells.
Yes.
As well as offer attorney's fees so that your work could be free. And if that letter were to come to Florida, I would say the same thing, because a lien on property, again, we have homestead protection here too, and protections against certain vehicles and things like that being lien. So if anybody in Florida gets a letter that says your property, lien against your property is a possibility, that would violate here too. And so we would be able to stack, I would be able to stack all three statutes, because Florida, California, and the federal statute, that would violate all three.
Yeah.
And I don't know much about the Texas law, but I imagine that would also violate Texas law as well. You could get injunctive relief, meaning the court could order them to stop doing that.
Right.
At least with respect to your particular individual client, if that's what you were looking for. So So yeah, so that letter could be a real problem for anybody that's receiving it in Florida or Texas.
Yes, it's a false threat to consumers, and it's a problem that we can resolve for them. And I think it's a big problem for Midland, frankly.
Yeah, I mean, I'm writing notes down as we speak, because I tell you what, as much as I do this stuff, and as often as I do this stuff, every time I talk to another lawyer, especially from another state who is you know, and Bill obviously is, you're neck deep in this, and you know exactly what you're doing. I always learn something new when I talk to somebody who does it with a slightly different twist. And so I'm making notes here to make sure that we start looking for that as well, because we've got letters we look out for, but I don't think that we've actually seen that particular letter, and I don't know if it's a Texas specific letter or not, but you know, but if I see it, definitely I want to help people do something about that. So
Absolutely.
If you're watching this, I hope you're taking notes, and if not, go back, rewind, and start over again, and take notes about everything that Bill's talking about, because he's got a lot of great stuff to share with us.
I'll be rewatching it for your comments too.
Well, yeah. Every once in a while, I'll drop a nugget that's worthwhile. So we've got a video on our channel that shows one of the letters that is going out about the pre-legal notification that, to me, seems designed to give the false impression that there's an imminent lawsuit, which is not, in my view, true, because the people that get that letter, I mean, I'd say about 10% of people who get that letters actually get sued so far, right?
Wow.
And we've been looking at those for about a year, maybe a little bit more. And I've seen, like, there's one guy in particular I can think of that's gotten sued. And I'd say we've seen probably roughly a dozen people respond to that video saying, I got that exact letter. They, you know, because the one I held up, you know, we had a color printout of it. And so it's like, you can see exactly what it looks like. And people like, oh yeah, I got that letter. And so, you know, definitely I'll encourage you, you know, go back, get a color version of the one you held up, because I think people, when they see the color of it, it'll, you know, better than the black and white, will actually, they'll see it, and it'll be something that their eyeballs will just like start going off, and they'll call you right away. So
yeah, I've made a video with that in there. And if you look at my Midland playlist, it should be in there. And I'll try to remember to ask you to put a link to it in this description of this video.
I was just going to ask that, is that I'm going to put links to the videos in this in the description for this video, and I think I may be able to actually even put links to playlists in the description. So we'll definitely feed that to you as well, and we'll list some of the important ones as well. So communications from debt collectors, anything they tell you that's false is potentially a violation, especially when they threaten to do something they don't have the legal right to do.
Right. Absolutely. That's common. The E2A, sorry to geek out on you, but 15 USC 1692 E2A, misrepresentation of the amount, the character, the amount of the legal status of the debt. That's got to be the most common violation there is. Debt collectors can't keep the amount straight between collection letters, credit reporting, and lawsuits. So
let's unpack that a little bit. So amount, character, or status. Amount is obvious. If they tell you that if they're trying to collect more than you owe, right?
Yes.
Then that's a misrepresentation as the amount. In theory, asking for less could be that too, but you might have a harder time making that case.
Yeah. Well, so what's the correct amount though in that case?
Right.
So are they underreporting it on your credit report, or are they over collecting it in the lawsuit?
Right.
I don't know. Right. So there's one amount that's accurate. And so collecting a lesser amount, does that mean that they've discounted it in one place and not the other? You know, it's up to them to explain. The
burden is on them to explain why they are telling you a number that's not right.
Right. Yeah.
Whether it's too high or too low. And then, so character status, or so the amount, character, and status. Character, well, status is, I think, easy. Like your status is it's paid off, it's not paid off, it's in collections, it's not in collections, it's in court, it's not in court, things like that.
Discharged in bankruptcy, not discharged in bankruptcy. Yeah, that's status, legal status. Yeah.
And then character. What are some of the character misrepresentations you might say people should look out for? When I hear character, I think like, is it a consumer debt versus a business debt?
Right. Is it a medical debt? Is it a credit card debt? Is it some other kind of debt? Character can mean a lot of different things, and I think it was just being inaccurately described debt.
Okay.
So there's not a real tight definition of the character of the debt.
Yeah, that's something I've not seen a lot of activity on, but I can envision. I mean, again, anything that's, because the thing is the misrepresentations are not limited to that and that alone. Any false representation about a debt in the context of a debt collection is a violation of the law. Those are just examples.
Absolutely. And it's broader than just that. Any false representation in the course of collecting the debt, not just about the debt itself. For example, 1692E3, the representation that a debt collector is an attorney or communication is from an attorney. Well, that seems pretty obvious. If somebody calls you and says they're an attorney and they're not, that's a violation. And that is a violation. But if you unpack that a little bit and look at some of the case law, if somebody sends you a letter and they're an attorney and there's a mistake in the letter, let's say there's a mistake about the amount, well, then did that attorney meaningfully review that letter?
Right.
Is there actual attorney involvement in that letter significant enough for it to be from an attorney? I would argue there's not, and that's a violation of E3.
So that's an interesting thing as well, is because a lot of the, and this is more true in the past, where you get a signature by an attorney, and that's designed to make people think that, oh, an attorney has this and they're going to sue me. And the reality is that the attorney's just renting out their letterhead or just signing a stack of documents they're not even looking at.
Right.
But if they don't actually, if an attorney signs a letter, but they haven't actually done some kind of due diligence to make sure the numbers are correct. Of course, if the numbers are wrong, that's a different violation. But, but if you get a letter from a lawyer and there's something fundamentally wrong about the letter, maybe they're just signing a stack of papers, and maybe they have a system in place that is a fraudulent system. And then that's a whole different issue, because then you're talking about class actions and whatnot, right?
Yeah, and you can see sometimes I've seen letters from attorneys that have a barcode at the bottom, which, why would you have a barcode if it's not part of some system for generating letters from attorneys? And there's that Seventh Circuit case that says that when a consumer receives a letter from an attorney, they know the price of poker has gone up. So
that's a great phrase.
It certainly intimidates folks to get a letter from a lawyer. And so if a lawyer's doesn't have any due diligence or meaningful review of that letter, that's a violation.
Well, it's funny, is I see the flip side of that a lot, because I'll get people talk to me sometimes and say, oh, I just want you to write a letter. And because they know that a letter from a lawyer to them has more meaning. So if they receive one, they know it's got more meaning to them, and debt collectors know that, and that's why they use that device.
Right.
Got it. So one thing I'm seeing from time to time is, especially now, instead of mail, debt collectors are relying on not just phone calls. And so I'm seeing debt collectors leaving voicemails for Joe Smith, but they're leaving it on Joe's mother's voicemail by mistake. Hey, Joe, this is, so-and-so debt collectors, and we want to talk to you about the $1,000 you owe. That disclosure, of course, as you know, is a violation. Anytime a debt collector discloses your debt to a third party, it's a problem. If they're just trying to find you, like location information is okay, but but disclosing the actual amount of the debt, for example, is a problem, or that it's even a debt collection is a problem. And then, but beyond voicemails, I'm seeing, and now even the federal government has started to acknowledge by regulation that debt collectors may start using social media, text messages, emails, other ways to reach out to people to find them and get their attention. The social media ones seem, social media and text messaging to me seem to be the ones that are going to be the ones that capture attention the most, because they're the ones like the social media thing, for example. One of the regulations that's taking effect in November is debt collectors will no longer be allowed to, as if they are now, try to friend somebody on Facebook without disclosing that they're collecting a debt. Like, you might get a false friend request from a debt collector, and then they use your Facebook profile against you. Well, you went on vacation, so clearly you have money, or, hey, you just started a new job, so now we're going to garnish those wages. So the social media, text message, email efforts, I think, are, they're the wave of the future. And the fact that now there's a regulation about them is almost suggesting to debt collectors, you guys should try this. Have you seen anything like that?
I haven't seen anything like that, and I need to read up on those regs. I know they're coming, but I've not seen some text messages in the context of TCPA stuff, but not just straight debt collection text messages. So
TCPA, just for the people who are not in the alphabet soup business, is that's the law that talks about automated messages to cell phones, including text messages.
Right. Anytime anybody texts you or calls your cell phone with an auto dialer without your permission, they violate that law, and there can be staggering penalties for that.
Especially in combination with debt collection, because you get we talked about stacking statutes. When you stack debt collection laws on telephone protection laws, suddenly you're looking at multiple penalties for wrongdoers.
Yes. Yeah. And the penalties per call, so they can add up very quickly. But I haven't seen anybody complaining about social media. I've had a couple of folks who've received emails. There's some question about the validity of disclosures, the initial disclosures in emails. I don't know if it just hasn't come to Texas, or if the folks here just aren't recognizing that.
Well, I think it's something that is going to be more common after the regulations take effect, because once there's a framework that's been government approved, I think more debt collectors are going to be moving into that sphere. Whereas now, most of the ones I think that are the big players are maybe a little cautious about it, and we're waiting for the government to move on that. And
I think you're right.
Because I haven't yet I've seen some text message issues. I've seen some cases where a debt collector will use a text message to send an audio file, like a pre-recorded voice message, which blows my mind. I'm drafting that complaint right now. But so I think that's going to be the wave of the future. So social media, email, text messaging in the context of debt collection, that's going to be something I think next year we're going to look back and be like, well, hey, it happened, right?
Yeah.
Because I think that, well, again, I think the regs take effect in November, November 1st. So I think, by November of 2022, we're going to really see more activity in that area, which may or may not be legal, but we're definitely going to see a lot more activity there.
Right.
So, credit reporting. There was something that we were going to talk about. There's that one phrase that you said earlier before we started the recording, lurking in the soft inquiries. And I just love the way you turn that phrase. Tell me what you mean by lurking in the soft inquiries means when it comes to credit reporting.
So a lot of folks will say that they don't have debts in collections, or they don't know what happened to they got a credit card debt that got charged off and they don't know what happened to it. They're not in collections, but So I'll look at their credit reports, because everybody that calls my office, I give them what I call a credit one sheet, which is a one-page document that I put together that tells them how to pull their credit report for free and what to look for when they read through their credit report. And so I end up looking at a fair amount of credit reports. And what I've noticed is that folks may not have trade lines, what they call trade lines, or accounts or debts reported by Midland or Portfolio Recovery Associates. But if you look in the soft inquiries, their names will be popping up, and they'll be checking your credit report every month or every quarter, a few times a year. And,
so let's unpack that just a little bit. So when you talk about there's no accounts, basically when you look at a credit report, there's these most reports will say, here's all the negative accounts, the ones that are in either collections or the ones where you've got a past due indicator. And so they'll appear often at the top of the report, right?
Right. There's adverse or negative. There's usually a subsection for that. Yes.
And so you'll know those are the ones that are the ones you got to pay attention to, because those are the ones that are hurting you on your credit score.
Right.
But what you're describing is something a little bit different, where that section may be completely clean or may not have the account they're talking about, and you have to look to a different part of the credit report.
Correct. Yeah. So folks will get letters from Midland and they'll say it's not showing up on my credit report. And then I'll look at their credit report and scroll to the end of it where there's the hard inquiries where you're applying for credit. There's soft inquiries where people who you already have an established relationship can pull your credit without it hurting your credit score.
So the soft inquiries versus hard inquiries. So a hard inquiry would be like, I'm applying for a mortgage, I'm applying for a car loan, I'm opening a credit card, and I apply for credit, and that application triggers a credit check.
Correct. Right? And that's a hard inquiry. And each hard inquiry lowers your credit score. It's believed to be between 2 and 5 points.
Right.
And that's because if you get turned down for one car note and they shop it around to 10 banks, then your credit score will lower by 20 to 50 points.
Because they figure if they have to shop it around, then you're not really all that
credit worthy as you appear. Right. So those are hard inquiries. And soft inquiries are for people that you already have a relationship with or that are allowed to pull your credit report legally. And so
what's an example of that?
Well, Midland, for example, Midland buys your debt. And as a creditor, they have the right to do soft inquiries on your credit report. And Midland, so 44% of credit reporting is from third-party debt collectors.
Okay.
Excuse me, 40% of the content of credit reports is reports from debt collectors. And so Midland and Portfolio Recovery Associates are two of the largest debt collectors on the planet. I mean, they what was last year? Midland recovered $1 billion from consumers.
Midland is $1 billion a year in revenue,
and Portfolio is right behind them.
Yeah, they're close. They're like number 2.
Yeah, and so they provide so much data to the credit bureaus that I feel like they may get special access. But either way, they do have the right to do soft inquiries. And so what you'll see is somebody will come into the office with a Midland letter and a credit report, and Midland won't be showing up on their credit report, and they're kind of scratching their head why. But you look in the soft inquiries, and they're lurking in there. They're lurking in the soft inquiries because they're just staking out their claim. I mean, they're waiting for some credit event to trigger so they can file a lawsuit. They're just waiting for something to happen on your credit report that will give them the trigger to jump into court.
So here's something I've kind of seen, and here's something that I think people might have experienced themselves, is that it seems like just when you're turning the corner and just when you're getting control of things, just when you get that new job, or just when you pay down that other credit card, suddenly that's when Midland pops out of the woodwork, or Portfolio pops out of the woodwork and says, aha, now we want our money. It's like just when things seem to be going right, that's when they attack. And that's because they're doing these soft inquiries, and they know, like they can tell from your credit report when things are going, when you have money, when things are going well for you. Isn't
yes. Yeah. And people, you're not paranoid. It's really happening. You know,
Right.
they do keep an eye on your credit report, and it's really happening. That's what they do.
They're
That's how
not
they
paranoid,
operate.
they're really out to get you, right?
Yeah.
Okay, so they lurk in those soft inquiries, and they when they see something, when they see that things are starting to turn roses for you, suddenly they interject and say, aha, now that you've got this new job and you're paying down your other credit card, you must have money to give to us. And so
Right.
that's when they'll do things like, if they've got an old judgment, they might try to collect on it.
Yes.
If they've been sitting on an account, they might file a new lawsuit, or they might just send you a couple letters.
Right. Yeah. They'll engage. I'm sure they've got algorithms. If you look at the filings for Midland, they've got mathematicians and they've got psychologists on staff to help them with their collection efforts. It's all in their 10K, their public filings with the SEC. So they've got people who have structured collection campaigns, and I'm sure they've got artificial intelligence that tells them what's the most effective. And I'm sure they've got some kind of triggering events on people's credit reports, so that when things start to get better for folks, when they start paying down debts or get that new job, then they jump on it.
I just wrote that down about the mathematicians and psychologists, because like, we know that they have lawyers, and the lawyers are designed to give them an advantage over the average person, right? Like the
Right.
non-lawyer. But what you're saying is their 10Ks, their government filings as a public company, they report to the shareholders that we're so good at this because we actually hire psychologists to get inside people's heads to give us an advantage over how people think, so that we know how to manipulate them better, essentially.
Yes. Some psychologists said, let's tell them we'll put a lien on their property. And I'm sure they had a mathematician test this against another letter that had slightly different language. And the mathematician said, this is the more effective. And so that's what they went with.
It's funny, the letter you held up, I just recognized the signature on that, Tim Bolin. It's Tim Bolin is the guy that signs most of the letters we see too. So
yeah.
Tim must be either a very busy guy, or he's got a very active computer printer. So I'd love to meet Tim someday.
Yeah. The real Tim Bolin, huh?
I know that we get a lot of letters that have his name on it. So yep. I think that might be my next video, is has Tim Bolin written you a letter, and see who pops up, because I'll bet.
That's a great idea.
I'll bet there's people who are searching for his name too. And I know I know nothing. I don't know if the guy's real, frankly, but you know, to put your name on all those letters, I mean, he might be one of the best known people in the United States behind
that's right.
Kardashian. So yeah, psychologists and mathematicians. So they are carefully designing their system to attack people at just the right moment, to maximize the amount of money they can squeeze out of them.
They're using the right words at the right moment, as designed by psychologists and tested by mathematicians.
I mean, the average person has like no chance against that system. No, because they know exactly what to say to rile you up, to make you feel guilty, to make you feel shamed, to do all those things to maximize the chances of you coughing up some cash.
Yes, exactly. They know what to put into a letter to cause you to call, and they have scripts for their staff, and they follow a script. The whole thing's calculated to squeeze as many, as you like to say, pennies and nickels and dimes and quarters out of people as possible, to the tune, like we've been talking about, of billions of dollars a year.
Wow. And so, and this is, and it's not just Midland that does this, it's also Portfolio, and any of the large debt collectors, any of the large junk debt buyers will have some version of this in their system.
Yeah, anybody who's not doing it is at a competitive disadvantage to Midland.
Wow. So I hear a lot of people who they think, for example, or they want to believe that, you know, because they negotiated a great deal on their car loan, that they're going to be able to handle Midland on their own, negotiate their own settlement, and they're going to get out of this unscathed somehow. Same with Portfolio, same with all these other junk debt buyers. And,
right.
you know, and I mean, I often hear these stories after the fact when I'm trying to unscramble the eggs that they've scrambled and clean up the mess. And, and so to me, it just seems like it's an object lesson of, you know, yeah, we're all smart, we're all handsome, we're all, you know, have more money than we know what to do with, but none of us are as smart, handsome, or wealthy as we think we are. We really, it's always good to bring in somebody who knows what they're doing in a particular area. You know, I'm a terrible plumber. You know, I tried to fix my own toilet one time. I had to call for help. I don't do my own plumbing anymore because that was a bad idea.
Right.
My plumber doesn't try to go to court either. So, you know, we can deal on that. You know, I'll do my thing. He does his thing. Other issues with credit reporting and junk debt buyers. I know that one of the things that we are able to see a lot of the times is because Midland, Portfolio, and the others like them buy up so much of this debt, they often are, as you said, one of the biggest impacts on somebody's credit report. And so that is also, I believe, one of the greatest opportunities for somebody to improve their credit if they've got these folks on their report.
Yes.
And so I know that like Midland and Portfolio, I know Portfolio has this statement on their website, and I want to say Midland has one similar, but they make statements talking about certain circumstances that they're willing to just wipe the credit slate clean, delete negative information from the credit entirely, and usually that's if you reach some kind of agreement with them that's proper, without disclosing anything confidential. Can you say that you've seen that to be something you can negotiate in certain circumstances?
Sometimes I've been able to negotiate the trade line deletion and you know, for partial payment of an outstanding account. They're not always willing to do that, and sometimes they want hardship statements and things like that to really get the best deals. But you know, generally, I can't always negotiate for trade line deletion. That's sometimes harder to get out of these folks.
But it's common. It's common enough. It's worthwhile asking.
Oh yeah, absolutely. You always want to ask for it.
So somebody whose concern is, you know, I've got a little bit of money to spend on this, but I really want to clean up my credit because I'm trying to buy a house or I'm trying to get a new job or whatever it is. They need their credit cleaned up. They need it cleaned up fast. That's sometimes is a way to get it done is to bring in somebody who has experience negotiating that and then go from there.
Absolutely. Yeah.
Because
like you said, I know people in Midland and people who work for Midland and can get these things taken care of for folks.
Right.
You know, I'm not calling the scripted frontline people.
Right.
I'm working with people who are inside of Midland.
You're not talking to the call centers and the cubicles that have little power, little authority, little knowledge, who are working maybe minimum wage at best. Well, I guess at best. Maybe I'm a little pessimistic about that, but they're not, you know, these are not highly paid employees with a lot of discretion and a lot of power. Really.
Exactly.
You're talking to the people who are levels above that, you know, maybe even the lawyers who are involved, something like that.
Yes.
People with power to make decisions. Definitely something that we see in our practice is it, you know, it helps to know who to talk to, because if you want, like, if your number one concern as somebody who has a Midland account or a Portfolio account or a cash account or a LVNV or any of these other junk debt buyers, if your main concern is getting the trade line removed from your credit report and cleaning up your credit, the important thing to remember is most of these companies, especially the junk debt buyers, they're in it for the cash. And if they get the cash they want, they're willing to offer something in exchange.
Exactly. Yep. They're only doing it to get money.
Yeah. No, I mean, they're very good at making money. They really are.
Yeah.
And so that's something to take away from this. So as far as credit reporting goes, I know there's a lot of people who think just like chucking in these template dispute letters and things like that are a good way to go. I've found, like I think you have found, that at least for some of these folks, you know, offering some kind of payment is usually a better way of, and a quicker way of getting things removed.
Yeah, offering some kind of payment. Yeah, and it's the situation they're in, right?
Yeah.
If somebody wants to get it removed quickly, then yes, give Midland a call and get it removed. A lot of folks dispute accurate information on their credit reports, and
does that blow up in their face? If
they can get mileage with that, then more power to them. But if people have inaccurate information on their credit reports, I always tell them to go to the Federal Trade Commission has got a dispute letter form that is, it's the government says it's valid and good. I always tell people to go there to get a dispute letter form and use that, because the bureaus will say it's insufficient, but if it's the government issued by the FTC, it's good enough.
So that would be, so one of the things that I like to tell people is that form letters don't work. And so that would be then an exception to that, which is the one form letter that does work is the one the government wrote.
Right. And as
long as you put the right information in.
It's got plenty of blanks in it. It's not a complete form. You know, it's got fill in the blanks and explain why you're disputing it. And that's the form to use, because if you fill out all the information in there, then the credit bureaus cannot say it's insufficient, which is one of their primary excuses for validating incorrect information.
Like, you didn't give us enough information to figure this out is essentially
right.
what they're, okay.
We don't know who you are. We can't figure out what you're talking about. That kind of thing.
Well, hey, if you don't know who I am, that's great, right? So, well, I mean, we've covered so much. Like, I feel like we could do 2 or 3 more episodes of this, but I think that maybe we should wrap up for today. But I want to make sure that anybody who's looking for you, and we're absolutely going to put contact information in the description of this video, so that if you're in Texas and you have a debt collection issue of any kind, you go to Bill. If you're in Florida and have any kind of question about this, you come to us. But we're going to put that information in. But Bill, go ahead and like tell us what's the best way for people to get a hold of you in particular.
Well, I have a website, clantonlawoffice.com. You can call me, 210-226-0800. I hope we'll put a link to my YouTube channel in the description. So any of those ways you can reach me. Call me or text me at that number. You can do either. So.
Okay, great. And the same thing, you know, certainly anybody who's already watching this channel, you've already heard my, you know, spiel. We have a website, ricardolaw.com. We have a phone number, 352-567-3173. We do a click to call link that we put in the description of every video we have. And then if you're already watching this channel, or if you're catching this on Bill's channel, if he's able to put this up, then you know how to find us with that link as well. So Bill, thank you so much. I mean, we've been going for, I think, about an hour now, and I hope everyone, I mean, I've gotten so much out of this, you know, and I do this for a living. So I'm really grateful that you shared your time with us today. I hope everybody watching this has got a ton of useful information about how to handle this kind of stuff.
Thank you for having me on your channel. I really appreciate it, Mike. And I've learned a lot listening to you. It's always a pleasure to talk to you.
Well, I'm so grateful you shared your time with me today. So listen, anybody who's watching this, if you've got a question about anything you've heard, drop a comment. If this was valuable to you, leave a like so that other people get to see it, and then subscribe to my channel and subscribe to Bill's channel. If you're in Texas and if you're in Florida, subscribe to ours, and so that you get to see this kind of thing all the time and get notified by the YouTube algorithm. So thanks again for watching, and we'll see you on the next one.